Welcome, everybody. Let's give it a few seconds and then we'll get started. All right, so I'm going to start. Welcome. Today is September 18th, 2025. My name is Cindy. I'm here at Russo Law Group, and I'd like to welcome you to our webinar entitled Key Insights on Probate and Estate Administration. Before we move forward, let's start with some housekeeping items. Your microphones have been muted for the remainder of the presentation. Feel free to chat amongst yourselves. Please submit all questions in the Q&A box. Marie Elena will address them at the end of the webinar. Please keep in mind that we have, you're muted for the remainder of the presentation. The recording, we will record this webinar. It will be shared with you via email. And as always, we value your feedback. Please submit and fill out and submit the survey at the end of the webinar. I'd like to present Marie Elena Puma. She's a senior partner here at Russo Law Group. She has 35 years practice with focus areas of estate administration and trust and probate. With that, Marie Elena, I'd like to pass it on to you.
Okay, well, thank you and welcome everybody this sunny afternoon on Long Island. We are going to cover a couple of things today. We are going to look at what is probate and when is probate necessary. What are the common mistakes during the probate and estate administration process? And how do you avoid making them? So here we go. So what is probate and when is probate necessary? Probate is a proceeding that happens in surrogate's court when a loved one passes away. It happens in the court in the county where they resided, where they were domiciled, or where they owned real property. The probate proceeding entails taking the original will, submitting it to the court along with other documents, and ultimately getting an executor appointed who receives what's called letters testamentary, which will allow the executor then to act on behalf of the estate of the person who passed away. Often, what I see from my clients is their first experience with probate is that a loved one passes away and that they go to a bank to collect a bank account. And they bring with them a copy of the death certificate and a copy of their loved one's power of attorney. And when they meet with the person at the bank, they send them to the bank officer, the teller, because they say, well, the power of attorney is no longer valid, which is correct because your loved one passed away. It's only good during their lifetimes. And they say, you need letters. And then the clients come to us and say, we need letters. What are letters? Well, letters are exactly what we were just talking about. Letters testamentary. And that's the legal document. It looks like a death certificate. It's one page with a raised seal on it. And that is the document that will allow you now to act on behalf of your loved one who passed away. It's almost like a power of attorney when somebody dies. So that is what I see my clients are finding out most of the time. They'll call me and they'll say, the bank said I need letters. What does that mean? So that is what probate entails. Probate entails now getting an executor appointed who's the person nominated in the will to get letters testamentary so that they can act on behalf of the loved one, and then to follow the terms of the will in terms of where those assets will go. As an aside, I just want to mention when somebody dies with a will, they're considered dying testate. If they were to die without a will, they're considered dying intestate. So you would have a similar court proceeding in the surrogate's court, but the person is called an administrator when there's no will versus an executor. And the laws of New York for intestacy will tell you who that person will be to be the administrator and then how the assets will be distributed. So it's a little different than a will because the will is the document that says who the executor is and where the assets go. And an administration proceeding is there's no will, so the law says who will be the administrator and how the assets will pass. What's also important to remember is a probate proceeding or an administration proceeding and the authority of an executor or an administrator is only over probate assets. So I want to explain to you the difference between a probate asset and a non-probate asset? It's actually very simple. A probate asset is an asset that is solely in the decedent's name when he or she passed away. For example, a bank account just in the name of John Smith, period. That's a probate asset. An example of a non-probate asset is an asset that within the title of the asset states what happens upon death. So a bank account owned joint tenants with right of survivorship, say between a mother and a son or a husband and a wife, that would pass automatically by operation of law to the joint owner. So non-probate assets pass automatically by operation of law. So you don't have to go to court to probate the will and to become the executor. Another example of a non-probate asset would be like a life insurance policy designating a beneficiary, an IRA designating a beneficiary, or even a brokerage account that is TOD, transfer on death. So it's important to remember that in probate, the executor only has authority over the assets in the decedent's name alone. They have no authority over assets that pass by operation of law, known as non-probate assets. Okay. The other thing I want to mention is any asset that was put into a trust during the decedent's lifetime also passes as a non-probate asset and is not within the jurisdiction of the court, and is not in terms of the distribution unless there is an issue. And the trustee of that trust is the person who will handle the disposition of those assets, not the executor. So, what are the common mistakes during probate and estate administration? So I have 7 main ones here, and we're going to look at each of them individually. So I'm just going to skip over this slide, and we're going to go through them one by one. So the failure to retain competent counsel. Well, you know, when you're acting as executor, you are acting in a fiduciary capacity. And you will see in the document like the will say you have the ability to retain professionals to assist you in serving properly. So you're allowed to retain an accountant, an attorney, a financial person for investment advice. So the biggest mistake before somebody is appointed and even after somebody's appointed is they don't get an attorney to make sure that they are doing what they are supposed to be doing as executor. Okay. The executor is responsible for carrying out the affairs of the decedent. Just like I said before, when you have a power of attorney, the agent under the power of attorney will act for the person. But in this case, you're acting for the decedent as the executor. You have to collect the assets. You have to manage the assets. You have to invest the assets. You have to make sure that debts, expenses, taxes are paid. And then you have to look at the terms of the will to make sure that you properly distribute the assets to the beneficiaries. So failing to retain an attorney at the beginning to guide and direct you, to get you appointed executor, and then to handle the estate administration process with you is a big mistake. So it is very important. Again, the document allows you to retain professionals to assist you, and you should do so. Mistake number 2 is failure to marshal and manage the assets properly. So people don't realize, what do assets mean? It means the person's tangible personal property. It means bank accounts, brokerage accounts, retirement assets, IRAs, life insurance policies, annuities, real property. Also, debts owed to the decedent. So, for example, if the decedent made a loan to a child, right, or there's a promissory note, or there's a mortgage. So the executor is responsible to collect all those assets into a pot and then to administer them in accordance with the terms of the will. Also, the executor is responsible to make sure that those assets are protected, preserved, safeguarded, because we want to make sure that those assets are there to be distributed to the beneficiaries. So it's important that if there is significant liquid assets, investments in the stock market, that the executor is retaining the counsel of an investment advisor. Okay, mistake number 3, assessment of the validity of claims and how do you pay them. So when somebody passes away, you'll start to see that they'll start getting in the mail credit card bills, medical bills, all kinds of bills that are outstanding, utility bills for their home, all kinds of things like that. So you have to, as executor, look at those bills. Make sure that they're valid. Look at those credit card statements. Were there charges on those cards that happened after the person passed away? So it's very important that you assess the validity of these claims. Once you assess that they are in fact accurate and valid, then you have to look. You may only have a finite amount of assets that may not cover all of the debts that are out there. So you have to look at and be advised by your counsel as to which ones you pay first. And right now, the way our statutes read in New York, funeral homes and people who provide funeral services are a protected class. So the funeral and the burial expenses are our number one priority for payment. There are also the administration expenses, the court fees, the attorney fees, accountant fees, and so forth, followed by taxes. And then we'll talk a little bit later about the different types of taxes: income, fiduciary, and estate. And then it goes through medical bills, judgments, secured debts, and unsecured debts. So there is a priority of payment. Hopefully, if you're ever in the situation of serving as an executor, you won't be in a predicament where you don't have sufficient funds to pay off all of the claims. Mistake number 4, failure to keep accurate accounting records. So I like to talk about this one because of the shopping bag executor. This is the client that comes into the office with literally a shopping bag or shopping bags filled with papers. There's no rhyme or reason to those papers. They're not organized in any way. And we just spend hours upon hours in the conference room emptying out these shopping bags and trying to put everything in order to make sense. So this is very important. The executor has both personal and a fiduciary liability to the beneficiaries. So they have to make sure that they're acting properly and addressing all of the financial issues. So once the executor is appointed, the executor will establish an estate account in New York. And that's the account that will hold liquid assets and things that are sold, the proceeds from that. If a house is sold, those funds will go into the estate account. It is going to be important that the executor keeps accurate records of the monies coming in, the monies going out, the income that's generated. If there's rental income coming from a piece of real property, all of that has to be accurately maintained, because during this course of the administration, the executor has to be able to address any questions that are presented by the beneficiaries as to status, what is going on with the assets, have they been sold, where everything is being held, how things are being invested. When the estate is distributed, now there could be partial distributions during the course of the administration, and there could be, and then there will be a final distribution at the end. There will be a document that has to be signed off on by the beneficiaries. Within that document, the executor needs to provide an accounting. Most of our times we're able to provide what we call an informal accounting outside of court versus a judicial accounting, so that the beneficiaries can see exactly what transpired during the administration of the estate. Okay, number 5, failing to communicate with beneficiaries. This goes along with what we just talked about, because beneficiaries are going to have questions. That's why the executor needs to make sure that he or she is keeping accounting records of what's going on. So the executor must communicate with the beneficiaries. The worst thing an executor can ever do is not answer the beneficiaries' questions. It is important that they respond in an effective and timely manner. What happens is, if you don't answer the beneficiaries' questions, then the beneficiaries will become suspect and wonder if something is not occurring properly in the administration of the estate. So disclosure, being open, is crucial to maintaining the beneficiary executor relationship. We talked a little bit earlier about providing an accounting to the beneficiary at the end of the administration of the estate. And 99% of the time here at our firm, we do it in an informal way outside of court. Unfortunately, if the beneficiaries have not been advised throughout the administration process, they may not be accepting of that, and they may demand that it is done through the court proceeding in a judicial accounting, which results in additional legal fees, additional court filing fees, additional time, and then ultimately the beneficiaries are getting less money in the end. So it's really important to communicate with the beneficiaries. Sometimes, depending on our family situation for that specific client, we'll have family meetings to keep them updated. Other times, beneficiaries may be represented by counsel when maybe the family dynamics aren't exactly what we'd want them to be. So we'll deal with counsel for the beneficiary to keep things going along the way. So communication is key. Okay. Number 6, mistake number 6, the proper timing of distributing assets to the beneficiaries. I said earlier that when you serve as an executor, you have personal liability as well as fiduciary liability. And this is really important because if you distribute the assets too soon and you are not positive that all of the estate debts, liabilities, taxes, expenses have been paid, then you are going to be on the hook to make those payments. So if you said, well, I think everything's been paid, I'm going to distribute the monies out to the beneficiaries, and then you get an IRS notice in the mail, you are going to have to pay that notice personally, depending on where that notice came along with the 7-month period. So the 7-month period is not a statute of limitations, although people think it is not. The 7-month period says that 7 months from the issuance of letters testamentary, which is like what we said before, is when the executor is appointed under the will. You have 7 months for creditors to present their claims. So unknown creditors, creditors that you don't know, have 7 months. I don't want to say don't know, that you are not aware of. They have 7 months to present their claims. If they haven't presented in the 7 months, then it is safe for you to make the distribution. However, why it is not a statute of limitations is because if there is a known creditor that you knew of or should have known of, so for example, the decedent was receiving Medicaid, but they don't file a claim within the 7-month period, but you knew that your loved one was in the nursing home on Medicaid, you are still going to be on the hook, okay? So you're not relieved that, okay, it's 7 months after letters of testamentary being issued, I'm okay. So you have to keep that in mind. It is not a statute of limitations. So a receipt, release, refunding, and waiver agreement are the legal documents that we prepare for the distributions of assets to beneficiaries. This is done in an informal way, and it includes an informal accounting, like we said before, outside of court with the judicial accounting, because that takes more money and more time. So the receipt and release agreement refers to when we make a distribution to a beneficiary, we ask them to acknowledge receipt of the distribution, to release the fiduciary with regard to that distribution in terms of what they're entitled to under the will, to agree to refund a portion of that back if somebody shows up in terms of a creditor, and to waive the formal judicial accounting. Okay, so that is how we usually proceed in this office. We also advise our fiduciaries, our executors, to put in that receipt and release that they're going to take commissions and what those commissions are. And we also advise our fiduciaries to hold what we call a reserve in the estate account for a short period of time, and to let the beneficiaries know that in the agreement in case something does come up, a creditor or a tax bill, within a reasonable amount of time. Okay, mistake number 7. And I'm just looking at the time, we're doing good on time. There are 3 tax returns, federal and New York State, that the executor needs to be aware of because the executor is going to be responsible for filing these returns. The first one is the individual income tax return. So executors will be responsible to file the final individual income tax return in April 15th of the final year. So that's something you have to make sure you do. The next one is the estate fiduciary income tax return. The estate becomes an entity and gets a social security number known as a tax identification number. So each year that the estate is open, the executor needs to file an income tax return. Now that will be based upon either a fiscal year or a calendar year. Individual returns or calendar year. Estate returns could be calendar or physical, depending on the situation. And the third item are estate tax returns. Whereas the first two items are based upon income, the estate tax return is a tax on the asset, okay? So for federal purposes, you may have heard that there is an exemption. Currently for 2025, you can have $13.99 million before you have to pay an estate tax to the federal government and file a tax return. In 2026, that amount is going up to $15 million. So most of our clients don't need to worry about federal estate tax returns. New York is a little bit different. New York's number is $7,160,000 for 2025. It's going to go up to about 7.3 million in 2026. We don't have that number yet. It's indexed for inflation. But the difference with New York and the federal, besides the amounts, is that for federal, you only pay a tax once you exceed that 13.999 million. You only pay a tax on the amount over it. New York is different. Once you're 105% over that 7.16 number, which is about 7.518, you have to pay the tax on the first dollar. So you lose the complete exemption. You go back to the first dollar. You may have heard that's called falling off the cliff, the estate tax cliff for New York. So you want to definitely make sure you take a look at that. Estate tax returns are due 9 months from the date of death. So they have nothing to do with a calendar year or a fiscal year. So it's very important that the executor has an attorney, has an accountant, has advisors, tax advisors, who are going to make sure that they file these tax returns. So how can Russo Law Group help you if you're serving as the executor? We can make sure you know what you need to do. We will get you appointed through the probate process. We will guide you through the estate administration process. We will make sure you file those tax returns and meet those payments. We will help you to minimize the taxes, make sure you take the proper deductions. We will make sure that you properly distribute the assets to the beneficiaries. We will make sure that you are protected. We tell our clients, when we represent you as executor, we represent you as executor. We do not represent the estate of your loved one. We represent you because you are the person who has the liability, personally and as the fiduciary. So our job is to make sure that you do everything that's right so that you're fully protected. We also will help with family disputes to avoid litigation. We live in a litigious society. We are seeing an increase in estate contests, in trust contests, and in litigation. So we try to, address these issues, disclose information if people are asking about it. Try not to get to a point where things are heated and in court. We will analyze the interrelation of these tax returns that we talked about, estate, individual income tax, and estate and the fiduciary tax returns. We will make sure we look, where's the proper place to take the deductions? Where will you get a better value for that deduction? So we will look at those as well and make sure that those are properly filed and that they're timely filed. And lastly, if our executor is the surviving spouse, or even if our executor is a beneficiary of the estate, who now you're inheriting some assets, we are going to make sure that you implement estate planning for yourselves that protect you, so that you have advance directives in place, that you have a will in place, that you have a trust in place, that now that you have these additional assets, that you are going to be protected with your own estate planning and making sure you leave a legacy for your heirs or charities or the people for which you would like to provide assets upon your passing. So that is what we do to help our clients. All right, so I'm going to turn to questions at this point, which is great because we leave 5 minutes for questions and it's 1:25. So I'm going to pull the screen over and take a look at what our questions are. How and where do you find or get letters testamentary? Okay, so John, that is the probate process. So again, the probate process occurs in the surrogate's court of the county in which the decedent resided or in which the decedent owned real property. And that is a court proceeding. You have to bring the original will, if there is a will. You have to petition the court to become executor. You have to make sure the court obtains jurisdiction over the distributees of the decedent, who are the closest living blood relatives and or spouse. And then once all of that is presented along with other affidavits to the court will review the will to make sure that it was properly executed and complied with New York statute. And if that's all in order, the court will admit the will to probate and then appoint the executor by decree and issue letters testamentary. The second question is, if the funeral bill is, there's a typo here. If the funeral bill, other immediate expenses are paid by a family member or executor before letters are issued, how is this handled? Okay, so if there are not assets, so like I said, the probate proceeding pertains to not to probate assets, not non-probate assets. So those assets are locked. So unfortunately, sometimes if somebody dies with only probate assets, there's no money available to pay things like the funeral. They have to wait for the appointment of the executor. So sometimes a family member will step in and make that payment. So you need to present that paid funeral bill to the executor, and the executor will reimburse for that funeral bill to the person who personally paid it. Okay, if they have assets in several states, do you have to apply with the court in each state? Okay, that's a very good question. So the answer is yes and no. So if the asset in another state is a liquid asset, such as, let's say, a bank account, a brokerage account, savings bonds, an IRA, life insurance, non-real property, then the letters testamentary that you receive in New York will work in that other jurisdiction, in that other state. The distinction for the no is that if it's real property in another state, then you must commence what's called an ancillary probate proceeding in that state for that real property. So that's the distinction. Real property requires an ancillary proceeding in that other jurisdiction, and that is why we advise our clients when they have property in Florida or the Carolinas or Georgia or wherever, that they do a revocable trust where they do the deed transfer during their lifetimes to put that property in another state into the trust to make it a non-probate asset. Next question. How to separate an estate account that was created for someone who died without a will or beneficiaries on an IRA into two separate inherited IRAs for the two children who were appointed as administrators. How to separate an estate account. I'm not quite sure I understand this question. So is the IRA, I don't know, Herb, if you could write back to me, is the IRA payable to the estate? Is that what you're saying? And not to the two children? Maybe give Herb a second to email, to write back. When he's doing that, let me assume IRA is payable to the estate. Okay, thank you. That's what I was going to assume. So if the IRA is payable to the estate, you're going to have to talk to the financial institution that has that IRA to find out what their rules are. One of two things could happen. One is they can pay it to the estate, and within 5 years, the estate has to fully distribute it, and that is going to cause you to have to pay the income tax out a lot faster at higher tax rates because the estate tax rates are compressed. So you get, like, once you hit like $13,000, you're in the higher tax bracket. Or some institutions will allow you to see through to whom the beneficiaries of the will are, and allow inherited IRAs to be established for those two beneficiaries. So you need to speak to the financial institution directly and ask if they would do that for you. So, and we do that all the time for our clients, and we have found that the majority of the financial institutions will allow it to go directly to the estate beneficiaries, which will give you a longer period of time, because assuming the beneficiary is not disabled, because there's a different rule for that, the children or the beneficiary would have 10 years to pay it out instead of 5. Yeah, so the IRA had no beneficiaries, so presumably it's payable to the estate. So another question came in on that. So again, you look to see if they will pay it out through an inherited IRA, allow the transfer in accordance with the beneficiaries of the will. Okay, so we are just about 1:30. I don't have any other questions here. So I am going to just make sure. Wait, somebody put something in the chat. So let's see what we have here. What happens to a disabled beneficiary in the term? So this is Mr. Evans or Ms. Evans. Are you talking about with an IRA? If you're talking about with an IRA, and it's yes, okay. So if it's an eligible disabled beneficiary, then it's going to be paid out. You're going to have their lifetime to stretch out the IRA. It's not going to be limited to 10 years. So, okay. So I think we are done. I think we've addressed, you're very welcome. Gotta thank you there. I think we've addressed wait, I think we may have one more question. All right, last question. There was no will. Okay, last question. If a house is owned by two different people, can you put each of their halves into separate trusts? Yes, you can. You would do a deed transfer as to 50% into one trust and 50% into the other trust. Okay, I think we've got them all. So I'm going to come back, and I thank everybody for today for attending this program. And I'm going to pass this back to Cindy.
I second that, Marie Elena. Thank you so much for that presentation. So why choose Rousseau Law Group? Our clients have consistently commended us on our dedication, accessibility, extensive experience, and comprehensive legal services that have brought them peace of mind and comfort. We're a boutique law firm founded in 1985. We have 3 convenient locations on Long Island, and we have 9 attorneys ready to step in and help at a moment's call. I invite you guys to visit our website at bjrrusseaulaw.com to further explore our service offerings and our vast catalog of informational resources. I'm pleased to announce that if you fill out and submit the survey, we will provide you with a $200 off coupon from our ordinarily $600 planning meeting.
And if I may just add one thing, we really would appreciate your completing that survey. It will be emailed to you after the program today, immediately after, because it lets us know what you thought of the program, what programs you might want to see in the future, what you liked, what you didn't like. This way we can, address what your needs are. Okay. You
Yes.
want to close, Cindy?
Yes, thank you so much, Marie Elena. Thank you guys for joining. Please remember, we will send you a link to the recording. Please also fill out and submit the survey, as Marie Elena mentioned. Thanks so much for joining. Have a great day. Be safe.
Bye. Thank you, everybody.
Bye.